A very warm welcome to this quiz on the topic of proved, disproved, and not proved. You see these three terms defined in Section 3 of the Indian Evidence Act. Let us go ahead and look at 10 multiple choice questions to better understand this topic. It is important for us to know that when a judge is appreciating evidence, right, which basically means that he is weighing the evidence that has come before him, he uses his discretion. There is no doubt about it. However, this is not absolute discretion, right? It is discretion that has to be bounded by the rules of the law, by knowledge and experience. Therefore, you cannot say that it is unfettered because it is not uncontrolled. Okay. Likewise, you cannot say that it is his own intuition alone. Also, the Indian Evidence Act largely does not deal with the appreciation of evidence. Therefore, the correct answer to this is option D. Well, talking about option A, not just the Indian Evidence Act, but most human undertakings, most things that human beings do in their daily lives are incapable of ascertaining the truth. That is because the truth is absolute, and it is hard to find out the truth by using these limited instruments such as the Indian Evidence Act. Now, when we talk of appreciation of evidence, the Indian Evidence Act does not deal with it. Indeed, it deals largely with the admissibility of evidence. The relevancy of a fact and the admissibility of the evidence are dealt with largely with the Indian Evidence Act. Therefore, the role for common sense in it is actually quite less. In fact, if you used your common sense here, it would be a mistake. For this, you look to the law. However, when you're deciding the weight of evidence, which is what is the evidentiary value or what you also call the probative value, this is basically the process of appreciation of evidence. So option C is basically the appreciation of evidence, and for this, common sense must be used. One might be tempted to think that when a fact is not proved, then the fact is kind of useless to the court, right? You might think that when a fact is not proved, it basically means that it is neither proved nor disproved. If you look at the definition of Section 3, it says that a fact is said to be not proved when it is neither proved nor disproved. So one might be tempted to think that this does not assist the court in arriving at a decision. However, when you see this along with the presumptions, then even facts that are not proved are useful in arriving at a conclusion. Therefore, the answer is D. You must remember that a fact that is not proved is still a conclusion. What is the difference between a theft of maybe a loaf of bread that is committed by a hungry person on the one hand, and what is the difference between theft that is committed by a greedy person who now steals maybe a necklace, a pearl necklace. Okay. Is there a difference between these? Perhaps there is. Now, when you look at the IPC, it talks of section 378, which talks of theft. Now here, this does not talk about a greedy person or a needy person. It does not make a distinction between a necklace or a piece of bread. So, this difference is not given to you in the black letter of the law. The peculiarities of the case are not provided in the black letter of the law. It is something that is known when the judge exercises his own discretion. Therefore, the answer to this is B. Well, in our regular day-to-day language, a fact is something that we consider the truth. However, you must understand that when we are talking about fact as defined in Section 3 of the Indian Evidence Act, it could be either true or false. Proof is the consequence of reducing evidence. So what that means is, let us say there is a fact. Now the fact is disputed, which means that one party says that it exists, the other party says that it does not exist. Therefore, to decide this, you have evidence. And now after evidence is admitted and after it is appreciated, the court arrives at a conclusion, right? And this conclusion is basically what is called as proof. And we know that proof can assume three shades. It can be either proved, disproved, or not proved. Okay. So proof is the consequence of reducing evidence. Proof happens as a result of evidence having been presented to the court. In case you have not got the answer to this question right, I strongly recommend that you pause the video and had a look at section 3 of the Indian Evidence Act and looked at the definition of proved, and then it will be fairly clear as to why this is the answer. Take your time to understand, assimilate the idea, and then move ahead. Now, let us say we had a fact. Okay. For this fact, the court looked at some evidence. Now, on the basis of this evidence, the court could either be convinced, which means that it could be sure, okay, or maybe it could not be convinced in the sense that the court felt that the evidence was insufficient, okay. When the court is convinced that a certain fact exists, then that is called proved. When the court is convinced that a certain fact does not exist, it is called not proved, okay. Whenever there is insufficient evidence for the court to come to a conclusion, that is when we say it is not proved. So therefore, when a fact is said to be disproved, it means that the court is convinced that the fact does not exist. Okay. Now, when you look at these three options do not talk about the court being convinced about the absence of the fact. You see, you will find that in fact these three options relate to not proved, right? When something is insufficient, then we call it not proved, when the court could neither know that the fact was proved or disproved. Therefore, the answer to this is D, none of these. On the same lines of what we just saw, we now talk about not proved. Now, when we say not proved, we tend to think that it is not a conclusion. However, you should remember that not proved is also a conclusion, right? Therefore, the court will not continue to receive evidence. Once a fact has been concluded to be not proved, it means that fact has been decided as not proved. Therefore, the court will not consider any more evidence. The court does not want to decide that it is proved or disproved. Once the court looks at a sufficient amount of evidence and it feels that on the basis of this evidence, it could neither believe that it exists nor it could believe that it does not exist, the court says, okay, this fact is not proved. I hope this quiz was of some use to you. In case you have any questions, you may please ask them in the comment section below. Good day.